All right, let's proceed. Yes, sir.
Good morning. My name is Daniel McCarthy, and I represent the appellant, Ella Boazova, who is also the plaintiff in the underlying action. In August of 2005, Boazova discovered damage at her premises in Arlington, Massachusetts. Specifically, the lower walls and sill of the premises had deteriorated by a process that was hidden and unknown, caused by water that had continually or repeatedly seeped into the premises over a long and remote period of time. The process was exacerbated by the presence of a concrete patio which had been poured directly against the wood sill, thereby fostering a persistently wet condition, and in which the alkalinity in the concrete accelerated the deterioration of the wood.
Mr. McCarthy, can you help me with a background question? What's the difference between a fungal rot and the alkaline damage from water that you're talking about?
According to the safety expert, the process caused by alkalinity is far more rapid.
Does it look different than like rotting wood, fungal rot?
I imagine that the ultimate result is similar, but according to Mr. Wilkin, it is
it's a different process of deterioration.
Different process and more rapid. And he makes statements regarding that particular element in the Record Appendix, Volume 2, pages 33 and 34.
So you're, are you saying then that the endorsement is not relevant to this?
Oh, no. The endorsement is relevant. The endorsement provides specific coverage for the particular peril that caused the damage. The constant...
Not fungal rot, and you say it's...
Oh, excuse me. Yes, I say that the endorsement for fungal, as it pertains to fungal, fungi and bacteria rot, wet and dry rot, is not relevant to this particular damage. It's not relevant for several reasons, but...
Okay, so if it's not relevant, but the endorsement is, I'm sorry, I'm just lost.
The language of the endorsement, it contains an amendment to the perils insured against portion of the policy.
Yes.
Specifically, it amends the exceptions that begin right out of it. And it specifies the very process that caused Boazova's damage, the presence of a continuing seeping water condition over a long period of time that was hidden and unknowable. So that provides specific...
So it's the 2E9.
2E9, yes, Ron.
Okay.
That's the only portion of the endorsement document that actually pertains to this matter. Safety, of course, denied Boazova's claim, and it basically treated the language in 2E9 as if it didn't exist.
Well, are they doing that, or are they saying that the seepage derived from surface water and the anti-concurrent clause bars it because it derived in part from surface water?
Well, the problem with the process that safety went through is they chose to characterize the damage as being resulting from surface water, when in the same anti-concurrent cause language there is a separate provision for damage caused by seeping water, which is much closer to what actually happened in this case.
Yes, but the, I mean, this is where the direct or indirect and the surface water, there's no dispute, is there, that you have rain coming on this cement patio and coming down into the gap and rotting the wooden sill, is there?
Well, there is a dispute, Your Honor, in that the safety never proves that that's what's happened. That's just a matter of surmise. Unlike the previous case, for instance.
But doesn't your expert also say that it was seepage from exactly that phenomenon?
What our expert says is that construction of the patio permitted moisture to
Isn't
find
that the
its-
source of the moisture?
Well, it may be, but it's not surface water. It was never, surface water never caused this damage as a peril that surface water poses. Surface water is pretty benign, as defined in the restatement, and it only causes a peril when it finds a way into, as in the previous case, it backs up, it flows directly out of a parking lot into a premise. And ordinarily, when surface water causes a peril, it's witnessed and it's easily provable. In this case, there's really no evidence ever that there was surface water on the patio or that how it got down there. And when it caused the damage, it caused damage as seeping water, which is a separate peril. And
Well, is there any dispute that, I mean, what other water source could have caused this? There were no leaking pipes in between the walls, right?
well, I'm not saying that it was not.
It was originally surface
It was
water.
originally surface water.
I mean, it
perhaps.
wasn't from cooking the steam that,
No, it was naturally occurring water.
yeah.
And I suppose that that's part of the problem with the exclusion itself, in the fact that it describes surface water in a group of other offending surface waters. It starts out with flood, which is also a surface water, and overflow of, it mentions overflow of lakes or streams, but which again are surface water. They're water on the surface of the ground. And the surface water is fitted in there, but the other forms of water that are specified in this entire exclusionary language all pose an evident peril to property when they in their existence. And surface water, being benign ordinarily, I think it's incumbent upon safety to prove how the surface water caused a peril. This damage was not caused by a peril that surface water ordinarily would cause. As a matter of fact, Mr. Wilkin testified that had surface water flowed into the sill on one occasion, as in the previous case, it would have caused no damage to the sill. So it's really the damage is caused not by surface water in its character as surface water. It's caused by water, naturally occurring water that has seeped into the premises.
And the damage is unknown and hidden within the walls or ceilings.
Right.
Is what you're saying.
Yes, and that's a separate peril. That exact peril, those elements of peril, are what the endorsement and what the insurance policy is designed to prevent. Something that is a fortuity, that is unexpected, cannot be reasonably accounted for as surface water ordinarily can be.
Is there any case law that differentiates between, within 2E9, seepage and leakage as if they were water from pipes or water that had come through a hole in a roof or a defective roof?
There is, Your Honor. It's brief, and the appeals court in, I think if I can find it.
It's in your brief?
It's in my brief. I believe it's Dilbert versus Hanover Insurance. In that case, the court addressed the seepage element of the anti-concurrent clause, and said that a pipe that had, which also, as you know from the previous case, has a component that excludes water that backs up from a pipe. In that case, a pipe had water in it. It broke, and the court ruled that the water that came out of that pipe was not excluded from coverage.
But when water comes out of a defective pipe, does it leak or does it seep?
Well,
Or doesn't it matter?
I think in Dilbert, the court used both terms, Your Honor.
Interchangeably.
Yes. I do want to take issue with the argument of the preceding counsel that this court in Jusim has endorsed the anti-concurrent language with respect to water damage.
Well, it certainly endorsed the language generally in Alton, didn't it?
Well, no, in that case, Your Honor,
Well, it's just, I mean, I understand the facts are very different. I get that. But in terms of an anti-concurrent language in a policy, it seemed to me,
well, because that was an advisory opinion, Your Honor, it does not come within the element of Jusim that spoke to anti-concurrent clause language was advisory.
no, I understand that, but in Alton it wasn't, was it?
Pardon me?
Do I have the name right? Isn't Alton the one about the police?
I'm sorry, Your Honor.
Maybe I've got the name wrong, which could well be.
In any case, since it does not come within the doctrine of stare decisis, the same question arises anew in litigation like this, and I believe it's for this court to make a determination specifically with respect to the anti-concurrent language and water damage, and should not rely on Jusim as having determined the issue.
And what do you say should be our rule?
I think that the language of anti-concurrent clauses should delete the word indirectly, frankly, in that insurers should have the burden of showing that there was direct damage from surface water. All of the other elements in the anti-concurrent language can be applied directly to a peril. And I think the court should focus on perils as opposed to euphemisms about damage, which is what the policies have in them now.
So you were saying that, so as I understand you, you're saying that an anti-concurrent clause would survive if it only guarded against damage directly caused by a particular peril?
Correct, Your Honor. Then the policy holder would be able to determine what the coverage is actually going to cover. The other issues that arose in the trial court but not in the appeals court with respect to the policy period, I think were incorrectly decided. In the instance of, first of all, if you look at safety's conduct, they never mentioned that as in the denial letter, which was found in the record appendix, volume 1, page 141. And they didn't raise that until summary judgment as an issue. And if you look at the language of 2E9, it pretty clearly contemplates damage that happened prior to the policy period and applies directly to damage that's discovered during the policy period. And I appreciate the court formulating a rule on that for future purposes.
That's because you're relying upon the seepage provision and not the dry rot provision.
Right. Well, that and the fact that safety has alleged and in the trial court found that Boazova's claim failed because the damage that occurred over a long period of time had not occurred during the policy period of 1 year. And I believe...
Well, I assume you take the position that it did occur during the policy period. It may have occurred before that, but it certainly occurred during the policy period as well, right?
Well, it really can't be determined when it occurred, but that the rule should be, I believe, and I believe the rule is elsewhere, that the damage occurs, the loss occurs to the homeowner when the homeowner discovers the hidden loss. And I think that otherwise the entire 2E would be superfluous language and contrary to the rules of construction.
Well, your time is up. I thank you very much.
Thank,
Good morning, Your Honors. Richard Moynihan for Safety Insurance Company. I'll try to address some of what my brother has raised, maybe going most recent in time and moving backwards. The issue with regards to policy period. This and all other property insurance homeowners policies in Massachusetts require that the damage complained of occur during the policy period. In this policy, it's in the full form endorsement, the homeowner's special
Does it mean it only within the policy period?
within the policy period.
But I mean, what if it extends beyond the policy period, but also within?
Well, there must be a manifestation of that damage within the policy period. In this case, Ms. Boazova opened up that rear wall and found that the wall was rotted.
Right.
She has never claimed that that rot occurred during the policy period.
Well, I mean,
What the distinction is she's pointing to an infiltration or an impact by water that occurred over an extended
yes,
period
but
of time.
rot is an organic process. It goes on.
Right, but based on the facts of this case, Your Honor, it's just as likely that that rot occurred before Ms. Boazova bought the house.
Well, what if it did and it continued to get worse? Does that make a difference?
It would be incumbent upon the insured, as the initial burden of proving coverage, to show that there was some damage that occurred during the policy period that would trigger coverage. In this case...
Well, let me ask it a different way. If, let's say they did get some expert, and the expert said, yeah, this rot has been going on for about 15 years, and there's sort of like a direct line correlation with time, so that, and she's been living there for 5 years, and I think I can give an opinion to a reasonable degree of certainty that 2/3 of this occurred before she moved into the house, and 1/3 of it has occurred since she has been living there.
That would have been expert testimony that would have helped Ms. Boazova prove that this loss occurred during the policy period. She hired an expert in this case and did not have that expert provide any opinion as to if any portion of this rot occurred during the policy period. I mean, the circumstantial facts of this case show that this patio in the backyard is tipped towards the house and that there was a cement cant placed along the rear wall of the house where the patio and the house interact. That was done before she bought the house, which was some 4 or 5 years before this incident.
Right.
So presumably, some prior owner, and both experts agreed as to why that cant was put there. They both agree that it was put there to deflect water away from the house. So presumably, some prior owner put that there to direct water away from the house.
Yeah.
That would lead to the conclusion that this problem is a long-standing problem, and maybe some damage had been discovered at some prior date. The other point is it was put in the appeals court recitation of the facts is that Ms. Boazova did not hire a home inspector when she bought this house. So again, I'm just putting out there that all of this could have occurred completely before this policy period, and it would have been on Ms. Boazova, as Justice Spina had raised, to hire an expert to render an opinion that some of this damage, in fact, occurred during the policy period. That would have met her burden of showing that there was some damage here that occurred during the policy period. As to the temporal element of the constant or repeated seepage that occurs over weeks, months, or years, that has to do with the interaction of water. And again, referring to some of the questions that Justice Spina had, the language relied upon by Ms. Boazova in this case, I would represent, deals with or is intended to deal with not water coming from outside of the building, as we're talking about here, but water within the wall, constant or repeated seepage within a wall, meaning a plumbing leak.
Why doesn't it say it if that's what it means?
I would agree with Your Honor that if Your Honors would look at some prior form endorsements, some of the
Do you
standard...
understand anything about this policy? I mean, this is the most incomprehensible piece of language I have ever seen, I have to say.
And it causes us a lot of, well...
Do you ever think about amending it?
Well, we didn't draft it, Your Honor. These are standard form endorsements used, and that's why a lot of these cases from other jurisdictions, they all overlap, because these form endorsements are used widely. But I would posit, and again, Justice Cordy had said earlier, particularly with the proposal or the language that Ms. Boazova is relying on, is there a circumstance whereby that would provide coverage and surface water, as we're arguing here, would not apply? and it is in the case of a plumbing leak. If there was a plumbing leak within that wall, that's not surface water. That's not any of the water damages described in the exclusion section. Therefore, none of the arguments in this case would apply. So certainly there is a scenario whereby that language would apply to a loss. It just doesn't apply to this loss. This loss, all of the evidence of both experts, of all the people that observed the loss, shows that this patio contributed to and assisted surface water in coming into contact with the wooden elements of the rear of this house. Now, an important point is my brother was trying to argue that there's some sort of ambiguity with the subsection 3 of water damage exclusion that deals with, it uses the word seepage. Well, that deals with water below the surface of the ground. There's no evidence in this case that we're talking about any water that is subterranean. The patio itself is on top of the ground. The wooden elements are on top of the foundation, which is above the ground. There's no subterranean water at play in this case.
So the rain falls from the sky, lands on the porch, and then through the porch it seeps into the wood.
The water falls from the sky in the form of rain or snow because of the tilt of the patio, migrates, follows gravity, and follows its natural progression downward, where it comes into contact with the house.
Right. So I guess the question then is rain, once it is on the porch, does it lose its quality as surface water? Because surface water is defined in De Sanctis as waters from rain, melting snow that lie or flow on the surface of the earth and naturally flow spread over the ground. Is a porch part of the earth, part of the ground, or is it part of a structure? Does it lose its quality as surface water once it sits on the porch?
And that very question has been answered in a number of jurisdictions. Safety argues that no, it does not lose its characteristic. Here, this water was not diverted into any sort of water course. It simply followed the natural progression of water on the surface of the earth. If your honors would look at some of the cases cited in the briefs, we have the Cameron case from D.C., the Smith case from Illinois, the Crocker case from Texas, and American Family Mutual from Wisconsin. Those cases all deal with this distinction between does surface water, as this court defined some time ago, does that only apply to water that falls on virgin earth to ground? And those cases say, no, that would be a very strained interpretation of the term, particularly in this modern world where most
Everything
of the
is
surfaces...
paved.
I'm sorry?
Where everything is paved.
Particularly in our area, Your Honor, where everything is paved. You've got parking lots, you've got driveways, you've got patios like we have here. In particular, the Cameron case...
Well, I mean, there's a difference between it landing on a highway versus it landing on part of one's home. Are these cases,
There are some cases...
speak of water that lands on one's home?
There are some cases in other jurisdictions that have talked about water landing on a roof, maybe, as not being surface water. But the cases that have dealt with water landing on a patio, like we have here, which is built directly on the earth, do find that it is surface water. It has not been, its characteristic has not been changed. It has not been altered from water that is just naturally accumulating on the earth during a rain event or a snow event, and then through natural processes percolates into the earth or migrates its way to bodies of water, either through underground migration or whatnot.
But something different happened here. I mean, I take it that the water, I don't know what the process is, bleeding or osmosis, it started going upwards, right, into the walls.
I would presume
And that's
that the process, that at some point, I think Your Honor is maybe talking about wicking, or the water wicking up through the wood.
Yeah.
But the process that set this in motion, so to say, the process that caused the wood to rot, and again, I would argue based on earlier arguments, whether it's alkaline rotting or fungal rotting, the policy describes wet or dry rot. Most humans know, or most adults will know, what rotted wood is. I don't think that is a truly ambiguous term.
But the water here didn't behave. It didn't do what we expect surface water to do. The way we've defined surface water, it didn't flow down a hill or percolate into the ground. The moisture stayed there, and then, as you say, it wicked upwards into the wood.
one of the experts said it sat. What happened is the surface water sat pressed against that wood. And over time, that surface water sitting there began a process of rot. And that leads to the other the elephant in the room in this case, is that the damage complained of in this case is rot. My brother has gone to great lengths to avoid any discussion of what this claim is about or what he's claiming as a loss. The loss is a rotted rear wall, so wooden elements that are rotted. There's no other part of this claim. It's rotted wood. This endorsement includes an exclusion. So it's not just the surface water exclusion that the appeals court found that safety had met its burden on, but there's also an exclusion for wet or dry rot in this policy.
Yeah, but he's saying it's alkaline rot.
But where, the exclusion,
The form endorsement adds an exclusion for fungal, wet or dry rot, or bacteria.
Is wet or dry rot include what?
an exclusion for it? I
Yes,
thought
Your
Yeah.
Honor. Yes, Your Honor.
Looking at,
If you look at the form endorsement, it adds to Section 1 exclusions an exclusion for, and it's exclusion subsection I, fungi, wet or dry rot, or bacteria. And the only way that this exclusion does not apply is if the insured finds coverage through an additional coverage for fungi, wet or dry rot, or bacteria that's added under Section 12A.
that's what I'm looking at, 12A.
12A is what Justice Berry cites in her dissent. Judge Curran also mentioned 12A in his decision.
Isn't that part of the?
That is an additional coverage.
Yeah.
I'm referring to an exclusion.
Oh, yes, but
It's different language, Your Honor, also added by the amendment. The endorsement adds the language that my brother relies on. It adds an additional coverage for fungi, wet,
Yes.
dry rot, and it adds an exclusion for fungi, wet, dry rot.
you want to run that one by me? It adds coverage and then excludes it?
As it
This makes
relates-
sense?
Yes, because the exclusion contains an exception, and it says, this policy will not cover any damage that has to do with the mere presence of rot is excluded, unless the insured shows coverage through the additional coverage, which again is what Justice Berry referenced. And it's curious to point out that in this case, Ms. Boazova is not seeking coverage through that additional coverage. She never has. My brother mentioned it in his arguments before you here. He's only seeking coverage through the 2E9 language, presumably because if Ms. Boazova had sought coverage through the 12A additional coverage, she would be limited to a liability total of $10,000 for this loss.
Right.
So, and if that wasn't clear in the briefs, I apologize, Your Honor. But there are actually two operative.
But she could have recovered for this damage through this endorsement?
That's
Are you
what
saying
Justice Berry argued.
Well, do you think she could have recovered $10,000?
No, I do not,
Because?
because she has not shown in any way that there is any damage involved in this case that occurred during the policy period.
Oh, I see.
But if she
And
could,
again, if she had brought
if she
in
had
her
done that,
expert-
you're saying that you would acknowledge that she would have been entitled to make a claim and recover up to $10,000.
Yes, if her expert, for instance, Your Honor, let's go back to the leaking pipe. The damage to the pipe itself, if found to have occurred during the policy period, would have been covered. Say, for instance, there's a leaking pipe within a wall, and a homeowner is walking in that area. There's no visible evidence of damage, and a foot goes through the floor. They investigate the claim, and they find that that area is rotted, and it's because there's been a slowly leaking pipe hidden within that wall for an extended period of time. We don't know how long. Well, the damage that occurred during the policy period is now you have a hole in the floor. And then you go through the analysis of what's covered and to what amount. Fixing the pipe would be covered to whatever cost it is to fix the pipe. However, the rot damage to the wood in that scenario would be limited by this endorsement and whatever coverage was provided in the endorsement.
But you do provide coverage for the seepage or leakage of water.
The language relied upon by my brother?
Right, that is
Constant or
covered,
repeated seepage or leakage of water within a wall.
which may arguably result in dry rot.
True. And that language is added by this endorsement, which deals with rot and mold and things like that. Just because that is adding a coverage in there in a limited fashion doesn't mean that it's illusory.
You're saying, I take it, that kind of seepage cannot be seepage from surface water.
I'm arguing that the language relied upon by my brother does not apply to a case like this that involves water that is exerting or causing the damage from an external source, like surface water.
Great, thank you.
Thank you, Your Honors.